Hi, and good evening to everybody who is tuned in. Welcome to the Legal Talk Show, a Hammurabi and Solomon Partners production. Thank you all for joining us this evening for what promises to be a substantive conversation on one of the most consequential labor law reforms India has undertaken in recent years. Over the next hour, we will move through four codes and eight core questions, not as an academic exercise, but as an exploration of what these reforms actually demand of organizations and how to build the systems, policies, and cultures to meet those demands. Over the past 6 years, India has fundamentally reshaped its labor market. We have added over 16 crore jobs, moving from 47 from 5 crore employed in 2017-2018 to 64.33 crore today. Unemployment fell from 6% to 3.2%, and crucially, 1.56 crore women entered the formal workforce. But growth alone does not ensure fairness or sustainability. The old legal framework, which had 29 separate labor laws, many drafted before independence, it was a maze. Employers struggled with compliance. Workers faced fragmented protections. Enforcement was uneven. But the code on a paper is merely intention. Today, we focus on implementation, on what these reforms mean when they meet the real world of factories, offices, construction sites, and gig platform. Let's begin. It's my pleasure to introduce our first speaker, Mr. Anil Tiwari, who is a partner at Hammurabi and Solomon Partners. He has over a decade of experience in civil, commercial, and labor law. Mr. Tiwari's practice spans arbitration, consumer disputes, legal metrology, and real estate due diligence. But it is his deep expertise in labor laws that brings him to this conversation. He is an alumnus of Campus Law Center, University of Delhi, and he has spent years working with organizations across sectors to navigate the complexities of labor compliance. Mr. Tiwari, the Code on Wages creates a unified definition of wages. For decades, this was contested ground. Different labor laws defined it differently. Different states had different interpretation. The result was endless disputes. Workers arguing they were owed deductions that never appeared in their registers. Employers defending practices that seemed routine but were actually illegal. Now, the code says here is what wages. Here are the statutory registers you must maintain. Here are the timelines for payment. Here is what can and cannot be deducted. Once you remove ambiguity from the baseline, once both sides know what legal floor is, what overtime means, what deductions are permissible, the terrain of negotiation shifts. You cannot haggle over what is already regulated. So, where does negotiation move to? What becomes the new currency of competition between employers? And how does this transparency, this removal of fog that often surrounds wage setting, actually change the dynamic of trust or mistrust in a workplace? So, Mr. Tiwari, what long term shifts do you foresee in how employers and employees will relate to each other as wage standards become more standardized and transparent across the board? Over to you, Mr. Tiwari.
Thank you, Shubham, and very good evening to all our listeners. I'm happy that we are discussing the reforms in the labor laws on Constitution Day. So, the recent reforms in labor law act a stepping stone towards the cherished ideals of our constitution, that is social justice and equality. The Code on Wages has, in fact, amalgamated the four existing laws, that is, the Payment of Wages Act, the Minimum Wages Act, Equal Remuneration Act, and the Bonus Act. So, the Code on Wages actually tries to strike a balance between the rights of the workers and also the ease of compliance for the employers. So, as you mentioned, I mean, there is one registration now for employers, single licensing, and single reporting or single return. The number of forms has been reduced from 20 to four now. The registers, there used to be 10 registers which were to be maintained by the employers. Now there are only two registers which are required to be maintained under the new code on wages. So that way it strikes a balance between labor's right, labor's protection, and the employer's ease of compliance. Now, so far as the impact of these new labor laws, or more so the code on wages on the employer-employee relation is concerned, I feel that it is going to be now more formalized. I mean, the ad hocism has now been done away with. I mean, everything is defined in the code, and you need to have I mean, everything, the working hours, the overtime payment, wages, everything has been defined. In fact, the definition of the wage, which was different in different acts, had now been unified. So there is going to be more formalization in terms of the HR policy of the organization. A more formal structure is going to take place, and therefore, this formalization will give rise to transparency also. There is an emphasis towards the digitalization of record. So more disclosure, everything is available to the workers to see. So this will improve the transparency within the organization, and that will reduce the conflict also between the management and the worker. So this new code on wages, in fact, will formalize the employer relationship, will improve the transparency within the organization. And so far, you mentioned about the negotiation also. So, so far as negotiation is concerned, I feel the negotiation dynamics will also change because now there will be more focus on the individual negotiation. Most of the things like working hours, the overtime payment, leaves, etc., are now defined. So the negotiation will shift towards the productivity, towards the performance, and that way the individual negotiation will gain significance. Uh, Also, the recognition of the trade unions that employees have unions having more than 51% of the strength will now be recognized, and also the increasing of the threshold to 300 workers for having a certified orders will strengthen the union only in large organization. But the for smaller organizations, I mean, it will be more towards internal mechanism of redressal of their grievances. So that is how I see the future relationship between employer and employee in view of the new codes. There will be more formalization, more transparency, and less disputes. Thank you,
Right.
Shubham. That's it.
Thank you, Mr. Tiwari, uh, for your thoughts on the topic. Second, now we have Ms. Yashodhara Burman Roy. She is a principal associate at Hammurabi and Solomon Partners, and she specializes in high-stake dispute resolution for Indian and international corporates. Yashodhara has argued cases before the Supreme Court of India, multiple high courts, and leading arbitral tribunals. She has secured landmark judgments in commercial disputes which relate to airports, infrastructure, energy, financial services, among other industries. Now, coming to the question, the Industrial Relations Code does something significant. It simplifies a lot of threshold. This is simpler than the old regime, but it is also wider in coverage, and it applies standing orders to broader categories of establishments. When you formalize discipline procedure, you quote, we will not arbitrarily suspend someone, we will follow process, unquote. When you require documented decision-making trails, you are saying every termination, every demotion, every restructuring will be defensible. This sounds restrictive, but in reality, this is protective. Protective of the organization's credibility and the dignity of the worker. Ms. Roy, what are the foundational HR and IR reforms that companies need to implement now to remain resilient under this restructured standing orders framework? And how do you help them see these changes as protective rather than constrictive? Over to you, Ms. Roy.
Thank you, Shubham, and thank you for such a glorious entry idea about who I am. I hope to be even a percent of what you have described me out to be. Coming to the industrial code which has come in, the first important threshold is the applicability of the standing order. Rightfully said that industrial code comes up with several changes. But when we start talking about industrial code, the first thing that always comes to our mind is on which entities or firms does standing order apply. Initially, our idea was that anything which has a manforce or a workforce of more than 100 people. But now that flex threshold has itself been raised, the bar has been raised for 300 or more workers. So any mid-tiered mid-sized company or a smaller company which has, let's say, up to 200 or 299, they are out of the standing order compliance. So this is a benefit to that particular company, that there is an increased flexibility whether they fall under the standing order or not. Now, this is the easy part. Moving on, the difficult part starts with retrenchment or the layoff closure threshold. Initially, for 100 worker or so, prior government approvals were required for establishment which had more than 100. Now, since the standing order itself applies to companies or mid-sized companies having more than 299, that prior government approval threshold will apply to those companies which have their worker force is more than 300. So this gives this resonates with what our government's idea of doing business has been all throughout. So far, workman definition only took into consideration supervisory. There was a threshold limit on somebody who was earning a particular sum. So who exactly is a workman? Do lesser role people who were also supervisors, do they get the benefit of being called a workman under the act? Yes, this industrial code takes that into consideration. Now there is also a threshold of earning up to 18,000 per month of a supervisory employee who will now follow into the bracket. Now, what entails of falling into the bracket? There's an expanded coverage. Now, before I delve further into it, two other things that are very important for us to understand and to help both the employers as well as the employees on the other side are to understand the concept of fixed term employment and the gratuity for them. So fixed term employment was never formally defined thus far. So we never knew that what happened to these employees who were contractual employees. Now they find finally a recognition under the industrial code. And more than that, not just recognition, what we had initially envisaged that only if you finish 5 years you will be applicable for, eligible for your gratuity, which was under my gratuity act, which has also been replaced now. What we see is that some on a pro rata basis, after 1 year of completion, gratuity for such fixed term employees are also allowed. Another very interesting thing is strike and the lockout. The definition of strike has changed. Now we have a concept of giving 14 to 60 days of notices, minimum a mandatory 14-day notice for all industrial. Initially, strikes would only apply to my public utility service industry sector. It would not apply to all industry. Now, strikes apply to all, but it comes with a caveat. What is the caveat? You give a 14-day notice. The definition of strike has changed. Why? The definition has expanded to make it a more concerted leave off by 50% of employees. Why? How does this help an organization? An organization or industrial sector is helped because now there is no more ad hoc leave. There is no absenteeism en masse in the name of a strike. There is a particular definition of what strike means. And where HR now will have to take a better look is into forming their negotiating council, that negotiating union. So prior to this, the Trade Union Act did not envisage a concept of a negotiating union. But now what we see is there is a negotiating union which requires at least a 51 membership of the workers or a negotiating council. Now what difference? The council has to be at least 25% membership where there are several different multiple unions. So what does this mean? There is a centralized bargaining in place. It is not ad hocism anymore. We also have a grievance redressal system where it is mandatory for establishments having more than 20 or more workers to have a grievance redressal system with women representation, direct access to tribunal. So we only talk about companies and protecting companies and the HR, yes, but how is an employee also going to be benefited? This is where it comes in, direct access to tribunal. Before, for retrenchment issues or for any particular termination issues, direct access to the tribunal was not there. But several ways, you have to be referred, there was a conciliation. Now you wait till the conciliation, 45 days of conciliation goes over, you can directly approach the tribunal. This is important. Compounding of the offenses is somewhere where our friends, our companies, they are very well supposed to be helped. How? Because that was varying across various laws. Now it has come streamlined that if you pay 50% of the maximum fine for that offense, it is now under one particular law. And it says very clearly that the compounding will happen by paying 50% of the maximum law. So this also not only gives me one particular benchmark, but under these several other 29 laws where it was all haphazardly spread out, there were also criminal angles. That decriminalization has also happened now. That because of the compounding of the offense, the tag of a criminal proceedings, that does not happen. And the best part of personally to me, and which we have advocated on and off or advised on and off, the best part of these entire four reforms have been the if not through definitions, the recognition for platform and gig workers. The if not the industrial code, and here I might be stepping toes into my fellow speaker, but the social security code does formally recognize a gig worker. It provides for creating a security fund for them. So your question to this was the basic outline. Now your question to me was very poignant. It was that how does my HR take care of this? Take care of this? My HR take care in the form I have to house in order. So I need to have my in place. My assessment to understand what are my current policies, how do I apply follow these laws anymore? Am I a mid not have a standing order? Do I need to adopt my standing order? I have to redesign entirety of it. I have to my HR has to have transparent communication, fair practices. They have to be in touch with my legal finance compliance team. We have to assess our manpower planning over permanent versus my fixed term roles. When I'm talking about my fixed term roles, I need to assess whether I have a kitty for the gratuity compliance. So these are something for a 90-day, there has to be an extreme audit and understanding what all workers I have, what all workers are protected, what has come into place, what has gone away, which all compliances I'll have to do, what gives me a penalty, what I don't. This entire 90-day compliance is the first 90-day, and it is time sensitive. This had to be started the moment it kicked in on the 21st of November. And from the 21st of November till the end of this year, till the 31st of December, compliances should be prepared chart-wise. Applicability of the standing order, my retrenchment, my fixed-term employees, my gratuity kitty. Now, what does it mean for the vulnerable groups? Now, this is a very interesting thing that we have now touched upon, that fixed-term employment, which is takes a point, why we keep going back to that. This is because now companies will have that autonomy to take a cost analysis as to what is the benefit of having my fixed term employee by taking out the kitty for my gratuity and seeing that any other liability I have versus my permanent worker. But this creates an unrest for the industry at large. So there are widespread ramifications on both sides, and that is where we are desperately awaiting the rules as to see that where exactly the gaps that the act has left, that what is the timeline, if there is a cap on the fixed term employment, whether there is a cap on the number of fixed term employees I can have. These are something that we are waiting for the rules, and we have to wait not just for one state, we have to see how it pans out state-wise. Similarly, when we are talking about strikes. So strikes are something that we have constitutionally known as a right. Now, with the new code redefining strike and giving a notice, there would be initially there may be mass casual leaves or spontaneous strikes. Some labor unions may see it as curtailing, but this is in principle a protection that we see from a company's perspective, that they are streamlined, they are aware what is happening. One thing that an HR has to do without batting an eye is creating their negotiating union, which is very important so that there is a centralized bargaining power. So, like, I would like to only highlight on the fact that the applicability of the FTE, the applicability of my standing orders, my gratuity kitty, the creation of my security funds for my gig workers, which is there in my manufacturing sector, in my infrastructure, which are labor, like unorganized sector. So taking their kitty out for social security, these are something that the HR has to mandatorily do in a 90-day time period, figure out their kitty and tick boxes one by one, train their line managers that who falls now under a workman definition, whether a lower level supervisory having crossing that threshold of 80,000, whether they fall. So this has to be a complete audit check, which is essential for an HR at this point.
Thank you, Ms. Roy. This was quite informative, and I trust the HR professionals who are tuned in have taken a note of all this. Thank you so much. Our next speaker in line, we have Mr. Rahul Jain, who is a partner at Hammurabi Solomon Partners. He has over 18 years of experience in corporate law, intellectual property rights, compliance, and litigation in general. So, pretty much every area of law. He has held senior leadership roles across the legal sector and is recognized for his expertise in corporate advisory, regulatory strategy, and complex dispute resolution. So, to start with you, Mr. Jain, the Social Security Code attempts a philosophical shift. For a century, social protection in India was tethered to the formal, stable employment relationship. You have permanent job, you have PF, you have ESI, you have gratuity, you are a contract worker, you are on your own. A gig worker, forget about this. The law did not just see you. But the Indian economy since has moved on. The fastest growing segments of the workforce are not factory workers, but delivery partners, freelancers, platform workers, people earning through multiple platforms, working with multiple employers, sometimes for hours that add up, sometimes intermittently. So at their own terms, at their own time, at their own hours. But the mechanism on paper is not the same as protection in practice. A delivery partner who is earning 500 rupees a day through a platform, how does UA and portability protect them if the platform itself is unstable or exits the market? How does gratuity benefit someone whose relationship with an employer lasts just 3 months instead of years? So, Mr. Jain, how fundamentally does the Social Security Code redefine the concept of worker protection in India, particularly as it extends to gig, platform, and informal workers? What does this redefinition actually mean for workers who exist outside traditional employment? Over to you, Mr. Jain.
Thanks, Shubham, and good evening, everybody. So, I was just thinking that why Social Security Code has been crystallized into one code, because what I believe from the kind of additions in terms of classification of the various types of workers, in addition to the existing traditional workforce, we have a very young janta in India. I think almost as you have said, Shubham, initially, that we have a very young workforce. So what I believe with the Social Security Code, what government has attained in terms of bringing out this code, they have given varied level of protection to classify different workforce, defining them, then giving some sort of protection which are traditionally being triggered at certain time period are being triggered earlier, and giving sort of protection in terms of their health, uh, sort of protection in terms of their senior citizenship, and all those things have come into picture post this code has been enforced on 21st of November. So I believe Social Security Code has taken care of the relevant needs of the young India at this point of time. Um, and I will try to put my answer in two form, because what employer in terms of their compliance playbook needs to do, and what employees in terms of their awareness, because if you talk about the gig worker or platform worker, they are not aware about things, so they need to be aware. They need to themselves get registered at the Shram portal, and then only they will be able to get some social security welfare schemes, and they will be eligible for it, because a lot of thing has been organized, but for unorganized sector employees, it will be more of a awareness from their side. Of course, I'm sure that literacy is not at their side, but then it's a responsibility of their employer to get them registered and allow them to have those social welfare schemes which are available, but there is no responsibility or liability of anybody to register them, so that they will be also being included, because schemes are there, but awareness to be part of those portals, because it's all online, needs to be given to these people, and so that they can also be organized. So having said that, I would like to say that social security has been traditionally been considered as a provident fund or employee state insurance or other welfare schemes. But here we will be talking about something which has been revolutionary, being given in this social security code over and above the traditional social security, in terms of so BOCW has been given additionally the social security in the form of cess. Then we have employee compensation. These are all traditional things I'm talking about in terms of disability and accident insurance. But additionally, this particular code has given a annual health checkup to all the 40 plus workforce in years, as a free annual health checkup from their employers. Again, the gratuity which is being triggered for all the employees, either say 5 years, post 5 years, or as per the Supreme Court judgment of 4 years, 6 months, is being triggered for fixed term employment after 1 year. There are a lot of old age pensions, old age protection schemes. There are social security schemes for unorganized sector, as I have told earlier. There's a social security scheme for gig or platform workers as well. So there's a formula in this particular, aggregator or platform worker scheme, wherein the aggregator has to contribute 1 to 2% of their turnover, and the welfare scheme is being kept up till 5% of their wages paid to the workers. So if we talk about the formula, say if a company is having 100 crores of turnover, then they need to do a contribution to 1 to 2%. So 1 to 2 crores has to be contributed, but it will be capped at 5% of the wages paid to the workers, platform and gig workers. So if say they are paying around 2 crores, then it will be 1 to 2%. So it will be around 10 lakh rupees. So that's how the formula has been identified, but contribution is mandatory as per this formula by the aggregator. So this is again a welfare scheme by the government of India. So to regularize social security in this particular segment, because this segment has been aloof across when the e-commerce revolution has come to India, I think around 2 decades back. So this contribution is very, very important. With respect to employers security compliances, I believe that classification is very much important. They need to classify their workers are falling under traditional workers as a full-time employment, or they are gig workers, platform workers, or informal workers, or contract labor. So classification is very much important, because post classification registrations come into picture, and then that registration allows that basis contribution either by the government or by the aggregator, whether you are falling under that category of eligibility criteria of getting that kind of requirement. Secondly, with respect to uh, uh, digital data management, I think you need to understand that, as you have told, that there has to be a Aadhaar linked incentive based scheme. So again, this registration is very much important, and it has to be linked with your Aadhaar and other registration formalities. and then only you will be part of that regularized HR and payroll system, so that you will be eligible for those schemes. So what I believe, employer has to take care of these stuff, so that they should not misclassify the employees working for them, and the proper contribution has to be made by the relevant stakeholders, so that they get their social security dues. Um, Additionally, in terms of any unorganized sector employees, they need to understand that their classification and applicability and registration has to be done, and they need to be vigilant. They need to be have a sort of vigilance on whether their provident funds or ESI or welfare scheme has been activated, and relevant contribution is being deposited, because these things can easily be tracked. So it needs to be taken care of, and all their digital identities in terms of linking of their PAN card, Aadhaar card, bank accounts details needs to be streamlined, so that all the benefits under the social welfare scheme will be transferred to them on a timely basis. So that's from my side in terms of concept of worker protection, because the different categories have been defined, and if the employer follow this particular compliance playbook, they would be able to properly register the workforce, and employees or a workforce needs to understand that what are their rights, and they need to be aware, and probably a proper awareness campaign should also be done by the employer or by the government, so that these people should be able to get benefit from all the social welfare schemes which are available through government of India.
Uh, Thank you, Mr. Jain. I personally believe that the comforts of modern life that you and I and all of us here on the panel enjoy, they are built on the backs of such gig workers, and we owe it to them to have a more robust system. So I completely agree with you, and thank you for sharing your thoughts on the topic. Now, for the next speaker, we have Miss Khushboo Kataruka. She is a partner at Hammurabi and Solomon Partners. She comes with over a decade of legal experience with commanding recognition for her knowledge of law. Based in East India, she specializes in matters before the Jharkhand High Court, Jharkhand District Courts, and leading tribunals, with particular depth in commercial disputes, land disputes, and mining law. So, coming to your question, Ms. Kataruka, the OSHWC code, I'll call it just code for the sake of simplicity. It consolidates laws spanning factories, mines, plantation, construction, sectors that you have extensively litigated with respect to, and the sectors where hazard is not incidental but it's intrinsic to the work. The old laws treated these consistently with gaps and overlaps. The new code sets unified standards, mandatory annual health checkups like we were talking about before, safety training, PPE certification, mandatory rest intervals, consent-based night work for women with transport and security. It empowers inspectors to become facilitators and not just enforcers. It raises accountability by requiring organizations to maintain documented proof of compliance. But this is what interests me, the shift in mindset that the code represents. The old regime often assumed that the workers knew the risks and accepted them. The new regime assumes that organizations are custodians of worker safety. They must be proactive, not reactive. That they must anticipate hazards and not respond to incidents. Ms. Kataruka, the question to you now is, what are the most significant shifts in workplace safety obligations under the code for high risk sectors like mining, construction, and manufacturing? And what are organizations in these sectors most unprepared for? Over to you, Ms. Kataruka.
Thank you, Shubham. Thank you for your kind introduction. And the OSH code, as we know, has now been notified, and it has consolidated 13 central labor laws, by way of a single comprehensive legislation. So that, in a way, has reduced the multiplicity and brought uniformity across various industries and states, so to say. And what I could see by perusing this code itself is that it has been rightly done so because there are certain safety regulations which have been taken very seriously by the government. And that this is a right step towards bringing uniformity across like industries in terms of safety standards. Because earlier we would see that by way of different acts of different industries, the safety standards also differed. So, by bringing this uniformity, it has become quite a reformative change that we can say. And coming to the safety standards that now we see in this new code that will be applicable across is most important that we see is that formalization that has been done by giving the appointment letters. It has been made mandatory that all the employees will be given appointment letters, and there will be a set format which will be notified by the government, through which there will be all the details that will be there. So that is one very much required standardization in the labor industry of our country. And this is, in a way, what I feel is also helpful for the employers, not just employees, because it will also bring in a lot of clarity in terms of the terms of their appointment and what kind of the job security that they can give. So everything will be jotted down in one, particular format. Secondly, the sea change that I see is in terms of the working hours that has been standardized. Earlier also, there were certain working standards that had been standardized, but this is in particular very helpful that there is a shift in terms of there will be 8 hour working standard. There will be 8 hours working in a 6 day week. And if it is a 4 day week, it can be done up to 12 hours without overtime. And if it's a 5 day week, about 9.5 hours in a 5 day week. And if there's an overtime, it has to be duly compensated. And there has to be, it will be the double the normal wage rate that has to be given. So this is quite interesting to see that there is a standardization of working hours across various industries. Now, interstate migrant workmen they have also been taken care of. There has been a special provision that has been made for them. And this will help the migrant, especially the construction workers, which we see, to get the benefits under the BOCW. There is a particular BOCW cess that we see with the fund that is there. So that will be rightly utilized in terms of, the portability of benefits to these migrant construction workers. And in fact, in this particular code, there is a toll-free helpline for redressal of grievance. So that is something which I feel is quite interesting to see, and it would be very helpful. Because we had seen during, especially during the lockdown days, how there were several workmen who were stuck in various, districts across the country, and there was nothing to address their grievances. So that is quite a reformative move from the government side. Coming to the health and safety standards, there is a safety committee that will be established. And that safety committee that will be established will look over and facilitate the voice of all the workers that are there. It will be on-site safety monitoring that will be given. And it will, in a way, empower the workers because there will be now a forum where they can make the representation in terms of any, prospective danger that they can see, any imminent danger in the workplace, or any issue that they want to bring it up in terms of the diseases that we see on and off. There's a lot of viral diseases that we see. So these representations can also be made beforehand, and then the safety standard committee has to take proper action and also has to forward it to the appropriate government, basis which the appropriate government or the particular authority which will be notified by the government has to make a proper inquiry into those representations. So that is a very good provision that I find. That was something which was in a very different format, and there was no standardization of any particular forum. Coming to the health and medical coverages, there will be free annual health checkups that is required to be given by all the employers to the workers. And even the plantation employers can now avail the ESI facility for the medical services. That is something that is much required. And there is one more very interesting aspect that I see is that there was different boards earlier before, under different acts. So approximately there were six different boards under different acts. Now there will be one single National Occupational Safety and Health Advisory Board. So that would be sort of, in a tripartite arrangement where it would be unifying or bringing the trade unions, the employers associations, state governments, all in one single platform under this, OSH board, so to say, advisory board in short. And the state government will also be a party to it to advise central government to set the standards, regulations for factories, mines, and BD and cigar factories, which is very crucial. And the board will also set the national standards across. So there will be uniformity for occupational safety, health, and working conditions that will be mandatory for states to follow, ensuring compliance, so to say. Another thing is that there will be a social security fund for the welfare of the unorganized workers, to which the amount that will be received from composition of the offenses as well as from the penalty. So all these amount that will be, collected will go towards a social security fund for the welfare of the unorganized workers. So that is also quite interesting. In terms of your question also, which focused also particularly on mines, mining industry, there is a separate chapter altogether in the code that I see, which has been dedicated to the mines, and a separate chapter that has been dedicated to the manufacturing BOCW organizations. And in fact, now women have been permitted to work in the mining with their consent, with their due consent. And there will be strict safety norms that will be given to the mining workers. And there will be different safety norms for the mine workers, which will be underground and who all will be working overground. And there are certain exemptions that have been given with regard to the work timings that I just mentioned. But in case there is any emergency that comes up, so the code has also particularly provided an exceptional clause wherein those working hours will cease to exist, and those laborers, in order to rescue other laborers who are stuck, can go there, and they will be duly allowed to go there and rescue those workers. And there has to be the training, proper training, vocational training that has to be given, and a rescue service will also be introduced by the central government in times to come. That has also already been provided in the code, but in times to come there will be a rescue service that will be standardized by the government in times to come. Another aspect that I see here that is important for us to mention is that if, let's say, there is any manufacturing that is being done outside of the country by any particular employer in the country, and if the safety norms are higher in that particular country, so the higher safety standards would apply. So let's say in the Indian context, the safety standards are in certain ways a little relaxed, but in that country where the employees is working for the employer, so the higher safety standards of the outside country will apply. So that is something which is a very good reform that we get to see here. And there are various other changes in terms of Section 30 deals with double employment. So let's say if an employee is working in a mine as well as factory, so that has been restricted. So that will curb over exploitation to a great extent, that one cannot be made to work in a factory as well as a mine. So there has to be certain restrictions that have to be laid down. So what we see overall, Shubham, so to say, is that there has been a sea change in terms of taking care of, the industries which are very prone to these, work hazards and the sort of working conditions that these workers and employees are working in. And the government has given due consideration to all the practical implications of what exactly happens in these workplaces, and has also taken care of all these norms, provided a proper forum, provided an advisory board, which will facilitate all the different stakeholders on one single platform. And in times to come, there will be a standard, like, your safety standards that will be notified by the government in times to come, which has to be complied by all the employers. So net, I think it's a very good reform that we see and in a good change that was much required to bring the uniformity. That's all from my side. Thank
Right. Thank you, Ms. Kataruka. Now coming to what comments we have received from the live stream on YouTube. We have somebody called K.R. Kirana. They have first congratulated Miss Roy on her brilliant articulation, and they have also followed it up with a question. And I quote, do you think the redefined gratuity eligibility is supporting the idea of 5 trillion economy? First question. Second, do you think small business and startups will have challenges in funding because of these requirements? So the question is open to both Ms. Roy as well as Mr. Jain. Over to you guys.
If I may, to my limited understanding, for a 5 trillion economy, when I think from this entirety of removing of the 29 codes and coming up with 4 codes, what I look for is two things: the formalization of the labor market. Now that we have gratuity protections for the FTEs, gig workers, platform workers, contract workers under the social security and everything, what I envision is a greater formalization, thereby leading to a much more predictable workforce mobility, and which will ultimately lead to an improved productivity, and thereafter which will help my company to understand what kind of discretionary spending I can do, that would reduce my dependency on a lot of governmental safety nets. It will give me a better financial stability. So when we talk about India's vision towards a 5 trillion economy, we are not exactly myopic enough to think from a GDP expansion. My understanding out of it is an inclusive growth. So when I think about inclusive growth, this code form, because of the formalization of the labor market, because of the improved social security, this entire architecture, and the fact that through the model of FTs, the companies have now the possibility of talent retention, and there is a chance of a stability. So when I'm thinking from a macroeconomic, the that help transformation this area into trillion. So coming to the challenges, yes, for the small sector industries, for startups and funding, this does a bit of action, and which is where we await the rules. For the challenges, we see there is a the financial liability, it triggers completely. Gratuity now becomes a recurring provision expense instead of after something, a long tail service after which I'm waiting. Now it is a recurring provision. There is a cash flow pressure for my small term industry. I will have the company in a startup might have to think if they have a weak capital, working capital structure, if they might face certain difficulty in forecasting what kind of workforce tenure they're looking for. So for them, but how, so if we only restrict their challenges, the restricted would be the payroll cost structuring, the sudden stopgap when it comes to the hiring flexibility, and the entire compensation package that we see. But the strategic perspective would be to build from a ESOP versus cash-based compensation structure, have a mixed workforce bag, having a fixed term versus permanent versus gig, then having my entire provisioning system in place for my payroll. So there will be several MSME reimbursement schemes for which automatically my startup will become allowable for. There will be tax reliefs. So there are good, bad for both. To summary, the 5 trillion economy, that is absolutely in vision with my code. It does not harm, rather it helps in line with the global standards. For my sectors right now, yes, there is a sudden stopgap, which I see, especially in terms of my working capital and especially in terms of my cash flow. But if we have a phased implementation, like we saw with the DPDP, they have already called out the rules. They took time, got me a three-phased DPDP implementation. So if we have a phased implementation, or with the particularly very robust financial support mechanism, because ultimately that is all that we look out for, tax reliefs, MSME structuring, etc., then we can have a balanced inclusion with a balanced approach, both for inclusion for economic as well as business viability for my small time businesses.
Mr. Jain, do you have something to add here?
Yeah, see, I think, of course, it will be a burden on the MSME and startups, and government has already given, earlier a sort of grants wherein, there could be some sort of rebate being given to them. But what I believe, targeted subsidies and insurance-linked gratuity models can be evolved, wherein, the support from the external, stakeholders can be given to them. But primarily, this gratuity 1 year trigger is there in fixed term employment and not other category classification of workers.
Right. Thank you, Mr. Jain. We also have a question for Ms. Kataruka. The question again is from KR Kirana. I'm sorry if I'm pronouncing your username wrong. The question is whether the safety committee that is going to be established is going to be industry specific, and whether the workers and management's representation will be there in the committee. Over to you, ma'am.
Thank you, Shubham. And Mr. Rana, to answer your question, so Section 22 of the code, if we see, that will cater to this particular safety committee standards, and the government is yet to, pass the orders as to what kind of. So basically, this provision, what it's saying currently is that by way of a general or special order, the government will require any establishment or class of establishments to constitute a safety committee in a prescribed manner. And this will definitely consist of representatives from both sides, that is, employees and workers, and that too has to be in a proportionate manner. So to say that the representatives of workers cannot be lesser in number than the representative of employers, and that has been very categorically stated in this particular provision. And these establishments would be like, factory wherein 500 workers or more are there, factories which are carrying hazardous process, 250 workers or more, BOCW work wherein there are 250 workers or more, and mines where there are 100 or more workers which are ordinarily employed. And under Section 14 also, the code has specifically provided the right of employees, where the employees can therefore make representation to the safety committee, and they can also bring to the knowledge of the safety committee of any imminent danger. So yes, definitely it would be industry specific, but the standards would be uniform. And the government is yet to give general or special orders who are required to constitute this safety standards, to answer your question. Thank you.
Thank you, Ms. Kataruka. We have another question from Ms. Pooja Rao from YouTube. And I would invite Mr. Tiwari to please throw some light on this question. The question is, among all the new regulations, are there any specific clauses that are now required to be included in an employment agreement or offer letter from a regulatory compliance point of view? Over to you, Mr. Tiwari, and I believe this is an open question. If anybody wants to pitch in, they can also do the same.
Sir, you are on mute, Anilji. I can also pitch in Shubham for this question regarding gratuity payments in fixed term employment.
Right, sir. Yes, right. Yes, Mr. Tiwari, I think you are on unmute and would love to hear your thoughts on this
Yeah,
question.
can you repeat the question, please?
Yes, Mr. Tiwari. So, among the new regulations, are there any specific clauses that are supposed to be included in an employment agreement or an offer letter from regulatory compliance point of view?
Yeah, so under the new codes, I mean, there have been a significant change in terms of the wage structuring and the agreement. I mean, the benefits have been enhanced to various contract labors and all. So the agreement now has to very clearly define what amounts to wages. I mean, there is a 50% rule also. It cannot, I mean, the wage cannot go beyond 50%. Earlier, the employers what used to do is to avoid the PF payment and the gratuity payment. They will increase the component of allowances, bonus, and all that. Now that has been limited. So that has to be very specifically mentioned in the agreement itself, that what is your actually the wage component, and it cannot go beyond the 50% of the total payable to the employee. So that way, these are some of the clauses which have to be very carefully drafted in the employment agreement as per the new codes.
Right. Thank you, Mr. Tiwari. Yashodhara, I believe you also have something to add.
Hi, Shubham. Thanks. So, rightfully Sir said, for the wages perspective, from the industrial code, there are monumental changes that we envision now. For example, starting with the very nature of my employment, what is my category as an employee? What is my probation period? I have to define that probation period. What is my condition for confirmation? What is my separation conditions? These are some things that are very specific now under the industrial code, with my notice period, termination ground, retrenchment, then my form from like I heard from Khushboo Mam's presentation on the OSH to for the security standards, reporting the workplace hazards. So these are some things that have to be inbuilt into the contract. Furthermore, when we are talking about reskilling, the entire fund provision, the kitty that I was talking about, indicating the employer contribution in cases of my retrenchment, for example, that 0.15% of my wages, these all have to be built into my agreement now, including the grievance redressal, which we had addressed earlier, internal grievance structure and everything. Everything we have to update and make aware through my new contracts, or no standardized contracts that we envisioned so far under my 1947 laws. Now we have to move forward and take these things in. If somebody has been already doing it as good prudence and practice, they are good. Otherwise, all of these have to be taken into consideration.
Uh, Thank you, Yashodhara. Uh, we have a couple more questions. We should quickly be able to answer that and move on. So, first question is from Manisha Sarkar. I'm so sorry. The question is, do we need to wait for rules coming into force for the implementation of codes? I mean, state specific. So I believe the question is, do we need to wait for rules, or can we start the implementation process right away? So it's an open question. Whoever wants to address this, please feel free to.
Wait for the rules because they will bring more clarity. And the Act has provided, given a broad guideline, but the rules will definitely bring more clarity in terms of, like, say, for example, for minimum wages, there is a provision for floor wages, I mean, the national minimum wage. But then the states have also been given liberty to kind of draft their own rules in terms of minimum wages, which cannot be below the floor wages. So I think there are various nuances which will be more clear and when the rules come into picture. So we should definitely wait for the rules to come out and notified.
And
Okay.
just to add to that, Shubham, basically what is going to happen is that all these various committees and boards that are being constituted, so they will be coming out with notifications and certain standards that they have to prescribe. So that is yet to come. The board will be constituted, or let's say the committees will be constituted, and basis that these rules will be notified.
Right. So I believe the answer in short is all in due time. Let's not rush. Let's wait for more clarity to come, and then compliance can take place. And now moving on to the final question, open to all, since all the panel members here are expert in litigating disputes, especially labor-related disputes. The question is again from KR Kirana. Uh, Dear panel members, one more question. Will the new labor codes have any impact on the litigations, both existing and prospective, and any disputes between the employer and employees? A little bit open-ended, so I would love for all of you to pitch in maybe very quickly.
So, very quickly, per our understanding so far, so since the laws have come into place, until and for the existing litigation, most matters will continue under the old laws until and unless the government comes up with a separate notification. But for the interim, there are certain prospective disputes which are again offhand, which we can envision is, so since the code now talks about there might be a temporary raise in the disputes. Why? Because employers would now try to adjust to the newer threshold. Suddenly, there might be layoffs to match this 300 threshold. So, how do we do that? Or the entitlement framework, the gratuity, fixed term. So, why, like Sir said, we have to wait for the rules is because the code has given the law now. The rules have not come in implementation. When does it happen? What is my kitty? What is the threshold? That is a state-wise rule. So, for during this interim period for this transition, this would be there would be a sudden ad hoc rise in terms of my litigation. But till so far the government notifies anything, the old laws will continue uh, unless stated otherwise. Yes.
Just to add to that, Yashodhara, the when we see these codes, they have been applied prospectively. So the date of implementation that has been stated is 21st November 2025. So certainly the employers are not required as on date. Later, if the government may come up with certain notification, as you said, that's a separate chapter altogether. But as of now, they are not required to make any retrospective adjustments or
No,
deductions,
nothing.
certainly, or
Right.
any impact on wages. So I think it is very much prospective in nature.
And Shubham, just to add on that, very categorically, it has been given under the Press Information Bureau thing by the government of India that till the time the all the labor codes are not fully operational, the all the 29 labor law are in operation and they will continue to be in operation.
Right. Uh, Thank you so much. Final words, Mr. Tiwari, on the topic, impact of the new code on litigation, both existing and uh, proactive. Sorry, both existing as well as prospective. Please.
Yeah, so as rightly mentioned by Khushboo, I mean, these laws cannot be given retrospective effect. So the existing dispute will still be governed by the laws prevalent at that point of time. And yes, in the interim, I mean, there would be a void. So once all the rules are notified, we'll see how to take it forward.
Right. So with those final words, I would like to put the event to a close. We have moved through four labor codes and multiple questions. We have heard from Mr. Tiwari on wages, Ms. Roy on industrial relations, Mr. Jain on social security, and Ms. Kataruka on occupational safety. The thread connecting them is this: law is a skeleton, it provides structure, but it does not breathe. Breathing requires leadership, systems thinking, and cultural commitment. The government's ambition in codifying labor law is sound, but the real test is in implementation. Will organizations see these codes as constraints to minimize or as frameworks for building fair, efficient, and sustainable workspaces? That answer will determine whether this reform is transformative or merely cosmetic. Thank you to our speakers for bringing their expertise to this conversation. Thank you to all of you for engaging with these critical questions. This has been the Legal Talk Show on the labor codes. Good evening. Thank you so much.
Thank you. Thank you, everyone.
Thank you,
Thank you.
everybody. Thank you. Bye
Thank you,
bye.
everyone.